Our next session is hosted by Cyril Amarchand Mangaldas. The topic of the session is Understanding Sports Arbitration. The session will be moderated by Manmeet Singh. The panelists include Harish Salve, Karan Bhardwaj, Kirtan Prasad, Nakul Dewan, and Vandana Gupte. I request the speakers to kindly come on stage. Thank you.
Good afternoon, everyone. I would like to thank MCI for organizing this panel on a really interesting and upcoming area of law. In this panel, we'll be discussing broadly three themes: various mechanisms for dispute resolution in the sports world and the growing role of arbitration, the implications of the National Sports Governance Act 2025, which has just been enacted, the potential for conflict between lex sportiva and national law, and if time permits, of course, we'll touch upon a bit of cricket. I will now very quickly introduce the panelists. Our first panelist is Mr. Harish Salve. He needs no introduction to the participants in this room, but I will still do my role. Mr. Salve is one of the world's leading international commercial counsel. He is not just a senior advocate, but also a King's Counsel. He has led on some of the most important commercial, constitutional, and tax matters in the Indian Supreme Court over the last few decades. He was formerly also the Solicitor General of India. In 2025, he was awarded the Padma Bhushan. Mr. Salve has very kindly agreed us to join us for some time to share his thoughts on this very interesting topic. On my left is Karan. Karan is the Chief Strategy Officer and Head Legal JSW Sports, where he leads the legal function and also looks after the long-term strategic vision of the group across new business ventures and athlete development. He works closely on media rights, team and player acquisitions, and commercial transactions and athlete endorsements. Then I have Ms. Kirtan Prasad. She's a counsel with RPC Legal London. She's an experienced commercial and financial disputes lawyer with experience spanning multiple industry sectors, including finance, automobiles, hotels, shipping, and sports. She represents clients before English Commercial Court and has experience of arbitration across institutions as well as ad hoc arbitrations. I have Mr. Nakul Dewan sitting on her left. Nakul has a diverse multi-jurisdictional arbitration and commercial litigation practice. He is also a senior advocate in King's Counsel. He has extensive experience in commercial disputes across various sectors, including banking and finance, construction, corporate, hospitality, media and telecom, mining, energy, and of course, he's done a lot of sports arbitration work as well. Then on the extreme left is Ms. Vandana Gupte. She's the General Counsel of Reliance Sports and Entertainment. She has more than 3 decades of experience, including legal practice before the Bombay High Court, and then thereafter as an in-house counsel. Over the last 14 years, she has been shaping the legal strategy for the sports vertical of Reliance Industries. She was part of the structuring and launch of the Indian Premier League and the Indian Super League. She leads the legal team for a portfolio of Reliance Group companies covering a range of sports. So we have a very interesting panel to help us understand a very interesting topic. Moving on to a discussion for the day. Various national sports federations like in India use the Court of Arbitration for Sports as an appeals mechanism from internal dispute resolution bodies, while others continue to rely on internal committees and procedures, though not necessarily for disputes. Mr. Salve, starting with you, in your view, what drives the choice between arbitration and internal mechanisms for resolution of core sports disputes? We know you've done a lot of these disputes. Is it purely about maintaining control, or are there considerations about cost, speed, and expertise at play?
I have mixed views about this. But the trouble is, sports now has become a very, if I may, and I don't mean it in a pejorative sense, a very commercialized activity. Sport is no longer enjoyed as the joy of sport. I had this live experience when I was appearing before the IOC panel. And I realized how it worked. The question was whether the young lady had been rightly disqualified. And it was very interesting that the people who functioned as the referees came and said, we don't do paperwork, we know what we are doing, and it's a yes or no decision on the spot. And take a football match where it's playing, and it's a decision on the spot. And back in the day when we used to play cricket, there was no electronic facility to see the trajectory of the ball, the way the ball. everybody accepted what the umpire said. So there was faith in the integrity of the system, and sports stood for integrity. Today, ecosystem requires sports to be regulated and ethics and integrity to be injected into sports. And I think maybe the time is right to do so, because there is so much money riding on the results of sport. So it's a changed ecosystem, and I suppose we all have to learn to live with it now. I mean, we had this expression, right? This is not cricket. It was an idiom where if somebody didn't behave properly, he said, this is not cricket. Can we use that today with a straight face? I don't think so.
Thank you, Mr. Salve. Ms. Gupte, as a general counsel, when you are structuring various contracts, how do you evaluate the effectiveness of different dispute resolution mechanisms? How do you make a choice between whether to go in for arbitration, court litigation, or other dispute resolution mechanisms, say mediation? So how do you, what goes into the considerations while structuring the dispute resolution clauses?
So first of all, thanks a lot for the generous introduction. I hope I live up to it in the next couple of hours. So, and thanks, hi everyone, good afternoon. And thanks to Manmeet for inviting me here. And I'm really privileged to be sharing a panel with such distinguished professionals. Now, coming to your question, I think there are a couple of questions rolled into one. So let me just unpack them one by one. So I think the first question you asked is about how do you evaluate effectiveness, right?
Yes.
Of dispute mechanisms. So what we do, yes, when we enter into a contract, apart from the rights we purchase or the investments we make in the sports, one of the questions that we always ask ourselves while drafting is, what if something goes wrong? And how are we going to manage this? So the answer is not automatic, or there is no one formula. It depends on the nature of the deal. It depends on how fast you want the resolution to be and such things. So according to me, it boils down to four things: speed, enforceability, cost, of course, and also the impact on relationships. So which is also very important in the sports ecosystem. So arbitration, for example, is speedy most of the times, while court litigation is long protracted. So it depends on how fast we need the answer. Enforceability is also a very critical factor to assess effectiveness, especially if you have cross-border transactions. It's only the choice is only arbitration, and we usually fall back on the international arbitration institutions. And of course, for domestic contracts, we then would lean on the Arbitration Act itself. Most of our contracts have domestic contracts have Arbitration Act, because it also has the courts are also supportive of the act, and it's a tried and tested procedure also for most of the parties. And of course, the cost is also a very important critical factor to actually decide the effectiveness, because unless you are really, the contract value is high stake, it makes no sense to go in for arbitration, which it would outweigh the cost of the arbitration would outweigh your contractual values. So we take all this, we try to balance between money, value, and also how relationships are impacted, because in sports, especially, relationships matter, because we come into contact with the same sort of partners, the same investors, season after season, tournament across tournament. So as far as possible, we try not to take up an adversarial position. And so in such cases, dispute resolution on amicable basis, we give a lot of importance to that. And we always have a tiered sort of a mechanism where the first step would be negotiation between the business teams. If that doesn't work, mediation. And ultimately, if nothing works, of course, you have to go in for arbitration or courts. So it's actually stress testing the mechanism. I mean, evaluating the effectiveness is actually putting it to a stress test. So that is something that, I mean, we have to just cleverly manage all this when we are drafting the contracts. So, yeah, I think there was a second point that you were.
Yeah, the second point was, what do you use most commonly? What do you end up using most commonly? Of
Yeah, so most commonly, I think predominantly most of the contracts have arbitration. So whether it is domestic contracts or whether they are cross-border. Cross-border, though, I don't think we have any other option because the courts, I mean, it's very unlikely that any foreign entity would agree to jurisdiction of Indian courts. And also the enforceability becomes a problem. So majority of even domestic contracts submit to arbitration. But interestingly now, many parties have come forth, like my experiences, they have asked us to submit the contracts to courts. Maybe because of the cost factor, because they're very conscious of the arbitration is very expensive. So if it is a lower stake contract, it makes no sense to bleed yourself on arbitration and erode your commercial value. So so I think though most of the contracts submit to arbitration, courts are also as relevant today. And internal mechanisms don't work for commercial disputes, like committees or internals, because commercial disputes have to go to a neutral party. So impartiality is also a very important factor. And there's one more factor which parties often consider while going to arbitration is also confidentiality. Because courts are very public, we don't want people, reporters sitting at the back benches taking copious notes for headlines of tomorrow. So, so that is also one of the, in my experience, major ask from parties.
when you say costs become an important factor, do you think the approach of Indian courts of finding ways to interfere in an arbitration process is part of the issue? Why arbitration costs are high?
Sorry, you mean if the interference of the court under Section 34 or?
There are various layers, right? It starts with the appointment of the panel itself.
Yes.
Now, of
Yes,
course, there have been
yes.
some judgments which have reduced the scope for interference there. But do you think at various levels, the scope for interference is what is driving up the cost for arbitration?
Yes, it could be because it also becomes more lengthy.
Sure.
The process goes on and on because even I have personal experience where arbitration is supposed to be a fast track resolution mechanism, but going on for years. So because as I said, I mean, it starts from like giving a notice, asking, there is a lot of negotiation with the parties on the arbitrator. It goes to the court, as you say, and there are many delaying tactics also that are usually practiced. And yes, and especially in sports, what happens is that time is really critical. So because, seasons are launched at a particular time, matches are scheduled at a particular time, leagues are like, seasons are also like predetermined. So there's no use if you ask for a dispute resolution and you get resolution after a season is over and you're not being able to exercise any rights at all. So it just defeats the purpose then.
Thank you so much. Karan, coming to you. JSW is associated with several sports, including athletics. What has been your experience of use of arbitration in sports in India, whether it be core sporting disputes or commercial transactions? Have you seen better and faster outcomes?
So thanks everyone for having me part of this panel, esteemed panel here. I believe I'm part of the audience as much as everyone else here, just with a front row seat. Just thought I'll take you back around 30 years ago when I was a professional athlete. I played for school, college, club level, state level. The public sector units were the only sort of professional outfits where we used to try to play for a job. We used to get paid in cash. So we didn't have any dispute resolution mechanisms or any such frameworks back in the day for unpaid dues. So I think sport has come a really long way since that time, and I'm really happy to see that. I think over a period of time, arbitration has sort of become the established mechanism for dispute resolution. In our experience as well, Ms. Gupte touched upon time being the essence. Sorry, is that better? Time being the essence, so I think we've also been on a few arbitration matters which have been fairly efficient, fairly quick, and have got the dispute resolved within time frame. Being franchise and team owners, I think it's in the best interest of us to have our best players on the pitch. Sporting performance also sort of impacts commercial performance. I mean, that's the hard reality also of the beast. So, thank you.
Kirtan, coming to you from your perch where you see disputes across sports and across jurisdictions, what are the advantages you see of choosing an institutional mechanism like CAS, the Court of Arbitration for Sport?
Because we're at an MCIA session, I think we all need to sing for our supper and say institutional arbitration is always the answer to everything. But leaving that aside, I mean, stepping back, there are two types of sporting disputes. The pure commercial disputes where, it's sponsorship rights, television rights, brand logo rights. And then you have the pure sporting decisions, which is your on-field decision, player discipline, doping. And then there's arguably a category which comes in between the two, which is ownership rights, which affect players and where they play and how they play. For the pure commercial disputes, as Ms. Gupte said, I think, any institutional arbitration would do. Increasingly in our practice, we're seeing a lot of people ask for non-sporting institutions like the LCIA, particularly for transatlantic deeds and things of the sort. And then on the other hand, you have the pure sporting disputes. This is where an organization like CAS really comes into its own and becomes very important. What is CAS? CAS was originally set up by the IOC for Olympic disputes and with a view to standardizing sporting results overall. Long story short, now CAS is governed by a much more independent body because there were challenges to the IOC's level of interference and control over the sport resolution mechanism. So now it's sort of run by ICAS. But CAS has 4 divisions, if you will. The first one is to use a court analogy, original jurisdiction, where contracts and other agreements actually provide for arbitration to be resolved under CAS. The second is an appeal procedure. So you have various federation rules, etc., which provide for first-level decision-making, and if that doesn't work, then you appeal to the CAS. Then you have the doping body, which basically governs the doping rules, and then you have lots of ad hoc panels, which are set up for specific sporting events like the Olympics, like the Commonwealth Games, like the Asian Games, which also CAS helps govern. For the pure sporting bodies, as Madam said, Ms. Gupte said, time is of the essence when you're looking at sponsorship, league, etc. But when you are challenging an on-field decision, time is all the more of the essence. So the timeline in a CAS arbitration is actually 24 hours. 24 hours for the dispute for you to put in your complaint, constitute the tribunal, hear, your submissions, and have the decision out. So it's emergency arbitration on steroids, if you will. So it's not just appointment within 24 hours, but everything done within 24 hours. And for that, the fact that you have a sitting body of people and panels who are au fait with all of this, and you've got it sort of set up on the sidelines of a tournament to challenge is very helpful. CAS also is seated in Switzerland with appeals to the Swiss Federal Tribunal. Some people say it's helpful because they hear a lot of sporting disputes. So as a court of supervisory jurisdiction, they are more familiar with dealing with these sorts of matters. The factors that militate against CAS is it adds another layer of decision-making for appeals, effectively. So you've got effectively the federation's decision, then you've got the appeal to CAS, and then you're going to court, and then you've got the court appeal procedure. So it adds another layer. The other one is cost, actually, because if you're looking at the average consumer of sports arbitration, it is the average sports person. Not all sports, and certainly not all sports people, are well-funded and well-resourced. It takes a lot of time, resource, and sometimes a lot of emotional effort on the part of these individual sports people to go through the entire process. And CAS has sometimes been seen as a bit of a distant organization, particularly if you are an aspiring athlete from a developing country. I think in the Caster Semenya case, for those of you who remember the South African athlete with the hyperandrogenization, or what the World Athletics Federation calls the disorders of sexual development issue, there were 3 medalists in the Rio 2016 Olympics. She was the only one that appealed it, despite all 3 actually being affected by the guidelines that the WA set. So those are sort of some of the pros and cons of CAS.
In fact, you brought up an interesting point of it may seem distant for athletes coming from the developing countries. Does therefore CAS offer an equitable forum?
I mean, I think is sports arbitration an equitable forum is a complete question mark, because these individual sports people quite often are actually the most vulnerable people in the entire sporting infrastructure is the individual sports person. And they are very dependent on their entire ecosystem to push them, whether it is their federations, whether it is their managers, whether it is their national Olympic associations, etc. So generally, sports arbitration requires a whole load of people to throw their weight behind the individual sports person to go through. I mean, for commercial disputes, it's much more straightforward, right? It's like any other commercial arbitration. It depends on the parties themselves and their equality of bargaining power, etc.
Sure. Thank you. Nakul, you have acted on large broadcasting disputes. Are you seeing more commercial disputes being resolved through international commercial arbitration?
Thank you for the question, Manmeet. Let me first thank Cyril Amarchand Mangaldas and MCIA for hosting this great event and for inviting me. But I'm going to take cue from what Mr. Salve said when he started this session. And if I was to just paraphrase it, he said, you've got to accept that in sports today, the commerciality of sports is today a reality. And we've got to accept that. And one of the reasons why, the commerciality of sports has become a reality is because of broadcasting. So I actually did some research. And there's a survey that's been done by Deloitte and Google for India. And it seems to suggest that by 2030, sports in India is going to be a $130 billion industry. Of that, broadcasting is going to grow approximately at 11% CAGR from now all the way until 2030. That's staggering. Now, we all know that when a commercial industry grows, disputes grow along with it. So certainly, I can see a lot of broadcasting-related disputes coming into play. Let's just take a simple example, right? I've done quite a few of these broadcasting disputes over the years. The nature of broadcasting has changed. What used to be television broadcasting is now broadcasting over the internet. You've got mobile phones. We've got a population of 1.46 billion. Lots of people have mobile smartphones. Cricket, which is, I think, the largest watched sport in our country, is certainly a relevant sport when it comes to broadcasting. And there are people who are fighting for their rights. Now, there are broadcasting disputes which are based on a particular tournament, which, as Ms. Gupte said, need to be resolved immediately. Okay, then there are broadcasting disputes which relate to a particular season. Most of the disputes that I have actually done actually have related to cricket. But there are other sports which actually take place in our country. And unfortunately, some of them fail because they don't get the money. There's been a failed experiment with tennis. That led to a broadcasting dispute because rights had been given away, but the league failed. So again, it isn't always necessary that the more money you put into sport will necessarily lead to greater disputes. Sometimes the sport just doesn't get the money, but it's gone ahead and sold rights, and that can certainly lead to a dispute as well. And this is not just a trend in India. If you look at the PGA Live Golf tie-up, which has now happened, one of their largest points of dispute was in fact related to the broadcasting of golf all over the world when they were looking at that merger. And again, that led to a dispute. So yes, I certainly see that the way, if sport grows to the degree that it's going to grow, there are going to be more and more broadcasting disputes.
Thanks, Nakul. Mr. Salve, coming back to you. You recently led for the Indian Olympic Association before the Court of Arbitration for Sport relating to Vinesh Phogat's disqualification. How was your experience of CAS as an institution and of CAS procedures?
Before I answer your specific point, Manmeet, I want to use my gray hair to give a little steer to this conversation. I don't think we should be speaking in the same breath about commercial dispute resolution and sports dispute resolution. So let's define our premise. Today, the kind of disputes which Vandana spoke about the disputes about broadcasting rights, dispute about team ownerships, disputes about today teams are property. And I don't think there's any difference between the commercial dispute between two people who claim ownership of shares of a IPL team or two people who claim ownership over the rights of a right to use a footballer in their league or something. These are, unfortunately, we have dehumanized sport, and it has helped improve the quality of sport because to bring in such large sums of money, you have to dehumanize it a little. So we have dehumanized it. We've made it into corporate. I mean, who would think that a company like Reliance would have a vertical for sports? So that by that on that hangs the tail. So, but let's not get into those areas at all because those are straightforward commercial disputes. They will be dealt with in accordance with any commercial disputes. Fighting over shares of a company is fighting over shares of the company. It doesn't matter if it's a company which runs a league or it's a company which produces aluminium. The real sensitive area about which there is a lack of understanding is resolving disputes between sports persons and between sports persons and sporting organizations who conduct the event. Semenya was a case of that. And incidentally, Semenya's dispute was not with any sports person. Semenya's dispute was with the way the rules had been framed, where certain female athletes were compelled to take certain medicines to reduce their testosterone levels if they were to compete as women. And it was accepted by the Olympic body that they had no established test results of the long-term effects of those injections, which they were forced to take or they were supposed to take in order to qualify. And that went up, and the Olympic, the Swiss system upheld it. It was finally taken to the European Court of Human Rights, which turned it around and said, "No, sorry, you cannot do this." So these are large. These are a very different kind of disputes, or the one which Fogarth had, and the way that exposed the manner in which these disputes are resolved. That poor child was sequestered in the Olympic Village. Now, for good reason, the discipline is in the Olympic Village. Nobody's supposed to come and meet you. But then she was approached by some friendly people who told her, "We will get you a bunch of lawyers." They got a lawyer for her who had not even interviewed her. The defense which they ran for her was that she was unaware of the weighing procedure. When she went into the witness box, the first question she was asked is, "How many, you fought so many, in so many events. Don't you know you have to be weighed?" She said, "Of course I know I was to be weighed." And she was asked, "Don't you know if you're overweight, you'll be disqualified?" She said, "Of course I know that." So there went her whole defense down the tube. And by the time they didn't allow the Indian Olympic Society to intervene. By the time we got our foot in the door, it was too late. The other way is the manner of selection of the arbitrators. I'm not commenting on the decision in that case. Suffice to say, we had some good legal points, but they didn't get resolved in a manner which I would consider satisfactory. It doesn't matter who won, who lost. At the end of the day, that poor child came out feeling that she had lost an opportunity unfairly. Now, in today's day and age, of course, you need a specialized dispute resolution mechanism. It cannot become formal. You cannot apply the same rules to that dispute resolution as you would to commercial disputes which may impinge on sporting or which arise out of sports events. Broadcasting rights are pure property rights. But the disqualification of a child or of a sports person or the results of a tournament, if they give rise to a dispute, and so much today rides, your whole reputation, your career, your profession rides on that dispute. that dispute resolution cannot follow either the timelines of commercial dispute resolution or the formality of commercial dispute resolution. And so you need to think outside the box to find a credible institutional mechanism by which no athlete should walk away feeling that because of nationality, because of color of skin, because of gender, or because of any such circumstance, that athlete has been shortchanged.
Thank you, Mr. Salve. For everybody's benefit, Mr. Salve also led for athletics South Africa in the Semenya versus Switzerland case, and so we're going to come back to you on that. Now, moving on from this theme to the implication of the National Sports Governance Act, which has just been enacted for sports disputes, particularly for arbitration. And Mr. Salve, what do you think, in your view, are we headed in the right direction? Is tribunalization the answer for sports? What this act proposes is a national sports tribunal with civil court powers, headed by a retired judge, with government representation and an appeal to Supreme Court. Mr. Salve, is this the right way forward in your view for sporting disputes, particularly core sporting disputes?
I don't think sporting disputes would be before this tribunal. There is a provision, section 20, which says any dispute which falls within the exclusive jurisdiction of the internal dispute resolution of a national sports body, any other tribunal or court, international federation, or court of arbitration for sports in Lausanne. So all your core sporting disputes are out. I don't know what this tribunal is really going to decide. And this is entirely my personal view, and I take full responsibility for saying this in public. The moment I see a tribunal presided over by a retired judge, I lose faith. Because we've seen far too often, if commercial dispute resolution in India is floundering as against where it is in other jurisdictions, we know why it is. So, and I make no, I don't mince my words when it comes to this. I have had the privilege of now being in England for 10 years, practicing there and working in their courts, working in their legal system. And it's a very different mindset which we need to bring to bear. So having a retired judge and then having a statutory tribunal means it will be subject to judicial review under Article 226. I don't know where this is all going to end up. So the Indian, and the problem in India is not the law. The problem in India, and I make bold to say, if arbitration is floundering in India, because Indian judges are over-interventionists. Look at the English law, look at the English Arbitration Act. There are far greater powers in the English commercial court to interfere right from the time a tribunal is constituted, the tribunal's jurisdiction, questions of law before ongoing arbitrations, and to interfere with an award. And see the number of cases where the English court actually steps in. And look at how narrow our parliament has been trying to make judicial intervention, and see how our courts sit and redecide cases, including now the new super jurisdiction of the Supreme Court under Article 142, where they, in a curative, they sit in appeal over an award and have the liberty to come at findings which are contrary to the findings of the arbitral tribunal. So in India, arbitration is a disaster, and I make no bones about it. You're lucky if you get it done quickly and keep it below the radar. I have seen what happens to big arbitrations in India. Don't even get me started. So let's keep the focus on sports dispute resolution. I don't think this tribunal is really what we are talking about, i.e., a tribunal of credibility to decide disputes between sports persons and sports organizations and disciplinary issues of disqualification, etc.
Do you think this then creates more of a residuary jurisdiction to the extent something is not covered by internal committees?
I don't know. I've had some occasion. I don't purport to be a super specialist in sports law, but I've had some occasion for the last 20 years to be dealing, including back in the day, election disputes in the Olympic Association, etc. And I have seen some of these issues. I really don't know what dispute should be decided by this tribunal.
Thank you, Mr.
Because if
Salve.
you see the exclusion in 20,
Yes.
the rules cover pretty much all the matters which are otherwise dealt
Yes,
with.
but it does talk about sports-related disputes, so it'll be very interesting to see how this evolves. It does, as you're rightly pointing out, carve out certain kinds of sporting disputes which are subject to the rules of any international federation, rules of CAS, and even internal rules of sporting federations in India. So it'll be interesting to see what this covers. Clearly, the government does want this tribunal to look after certain kinds of disputes. But as Mr. Salve said, tribunalization may not be the answer. Nakul, coming to you on this while we are discussing the statute, do you think the provision there about sports-related disputes, somebody is going to get creative and stretch it to commercial disputes and bring up the issue of arbitrability?
Help agree with what Mr. Salve said. And he said, I don't know what this tribunal is going to decide. So when you actually put that question to me, I looked at the act and I said, I honestly don't know what this tribunal is going to decide. Because if you've excluded sports disputes, then are you really going to be looking at disputes which relate to elections of a particular body? I'll give you an example. We've had in the Supreme Court of India, I think right through 2023 till close till till 2025, you have had a dispute related to the election of the AIFF. And you've had a committee that's been formed by the Supreme Court, which has now started looking into determining whether or not the rules are all right, whether those require to be changed, what the election rules should be, who should constitute the AIFF, etc., etc., etc. Now, if you're looking at taking those disputes out and sending it to the tribunal, that's one thing. But those are not sports disputes. Those are administrative disputes in relation to sports bodies. So if that's the interpretation that Section 20 is going to lead to, then we have some sense of where this is going to go. Are you going to be able to take a commercial dispute out of it? I think that, again, is going to be a stretch because I think, as Mr. Salve said, at the end of the day, a broadcasting dispute is nothing else but a commercial. Broadcasting dispute is nothing else but a commercial dispute between two commercial parties. And I see no reason why that dispute wouldn't get adjudicated in terms of what the parties have agreed to in their contract. I don't know. The mic isn't working. Is this working? Okay, great. So, again, I mean, a broadcasting dispute is nothing else but a commercial dispute. It's based on a contract, and there's no reason why the parties would not be asked to follow their contractual mechanism for the resolution of such a dispute. Oh, there's only one mic.
This works. So the jurisdictional hook in the Act appears to be sports-related disputes, and that's the exact same expression which is used in the CAS rules. So it'll be interesting to see how the jurisprudence evolves around this. But given that there is a lot laid out about how the sports federations are to be governed in the statute, I think what you probably identified as the residuary category, maybe that's what, the disputes relating to internal elections.
Sorry to intervene. Sorry to intervene, but one important thing which you need to debate is, does this law prevent the Supreme Court from writing up constitutions for sports bodies? Be it the BCCI, be it the AFFI.
Salve, you are the best situated to advise us on that.
Because if it doesn't, then the law should be amended to provide that each sports organization, through its elected committee, will have the right to decide who's on the committee and how it should be run. Not by saying that there will be an expert committee constituted by Supreme Court, and then people will give objection, and then the Supreme Court on the judicial side will decide what should be the constitution of a sports organization.
The Act does go some way in this direction. It does set out who is to be on the committee and how many members and what the composition would be. So maybe the Supreme Court would start holding off after this.
Yes. No, it speaks of the National Sports Board, but I don't know whether it says that the Indian Olympic Committee And it should have gone further and said the Board of Cricket Control and the football federations, they all are democratically elected bodies. They shall have the right to set up their own constitution.
Nakul, sorry, you were saying something.
No, sorry. I mean, if I don't know. I think I don't have a mic that works. But I mean, I don't have the gray hair which Mr. Salve has, so I have to be a little more careful with some of my comments on stage. I think I think it's very fair to say that tribunalization hasn't been the most effective, right? And certainly, if you get retired judges to helm a body, in particular a sports body, where they apply, their experiences in court to determine a sports dispute, I don't think you're doing sports persons too much of a favor because they've really never been at the helm of affairs in, figuring out how sports disputes have to be adjudicated. So that's one little marker that I think is important for us to put here. If you do think that your sports federations are not being well run, and that's the reason why you want to create an independent body of adjudicators who will, without fear of any favor, adjudicate a sports dispute, then certainly you must look at a very different composition for such a body.
So while we are on that, Mr. Salve, I know you will have to leave at some point, so I will put this question to you first. The government of India has been wanting to develop India as an arbitration hub, and that's been the stated policy. Of course, I think the government does do a bit of flip-flop at times, but that's the broad overall policy. There have been unsuccessful attempts in the past to set up an Indian institution for sports arbitration. Given the exponential growth of sports in India, do you think the time has now come for an Indian arbitral institution to adopt specialized rules for sports arbitration on the likes of CAS and become a viable alternative, at least as far as domestic tournaments and leagues are concerned?
I think this law does not do so, but we should expressly provide, and again, I'm to borrow Nakul's word, using my gray hair to say things which he would be embarrassed to say. It should be a judge-proof law which provides for setting up of an organization for resolving sports disputes. It should identify the people. It should identify who will appoint those people, and especially for the CAS, the government should appoint people because after the statute should set out what their qualifications should be. They should be sports persons. If it is a football dispute, it should be people coming from the sport of football. If it's a cricket dispute, it should be coming from that. If it is a other gymnastic or other dispute, it should be people coming from that calling, and they should be asked to decide. The government will nominate because the government has no stakes in the matter, and that decision should be final and not subject to judicial review. And this should be made very clear. And I think there is a need for that today, to have a CS-like system if sport in India is really going to grow and be streamlined and be made transparent.
Taking notes somewhere. So, Karan, coming to you, from an industry perspective, how would you view this new act, and what do you think would be the impact of this act on sports governance and sports disputes?
Thanks, Manmeet. We have around, I think, 57 national sports federations registered in India. You see quite a few of these number of federations within one sport cropping up because of the commercial nature that it is today. I think one way is this act may sort of bring it all together in terms of best practices. But my real question would come with the IOC charter, which sort of clearly outlines that government interference within sport is to be kept away. So I think that is something that is a question that would need to be answered. I know in the UK and Australia they do have such acts, but it's only related to funding, not related to oversight over elections, committees, etc. So I think maybe taking cue from best practices there would really help. I think that's something and I think the intent around it is important. My being an ex-athlete, I always feel that rather than try and control sport, I feel such mechanisms should support sport. I think that's the key here.
That's a very interesting perspective. Don't regulate, but support. Uh, Nakul, coming back to you, given that there are parts of broadcasting aspects which have a public law element to it, do you think such disputes should be resolved by a private arbitration process? There's certainly some public interest involved in broadcasting sports, particularly in a country like India, which is there's a lot of interest to do with some sports at least. Do you think a private arbitration process is appropriate?
I have a mic. Yes, now it's working. Let me give you a slightly different example. I'm going to give you a non-sporty example, and if you agree with me on that, I think you will agree with me on the answer that I'm going to give you. So about 15 or 18 years ago, there was a dispute related to a West African country which had had massive water problems, and it was also in a massive financial deficit. So it got funding from the World Bank, and one of the conditions of funding was in relation to repairing its water system and its sewer system. And again, the condition of that funding was that if there was any dispute with relating to the water system, which then had to go to a private agency, it would be resolved by arbitration. Now, we know water is critical. We realize that the sewer system in any city is critical, and there was certainly a dispute, and that dispute went into arbitration, and it got resolved. If a dispute of that magnitude can be considered as commercial for the purposes of resolution through arbitration, because it relates at the end of the day to funding that's come in, then surely broadcasting rights are nothing else but a commercial dispute. So yes, there may be viewers, there are lots of viewers in India, but at the end of the day, that public interest is in entertainment. It's not in something like water or the sewer system. So, I mean, in my view, broadcasting disputes still should go to arbitration, and they can't be made the sphere of a writ petition that gets filed, in a court under Article 226 or a writ petition under Article 32 for the purposes of saying that, it's the courts which must determine how broadcasting rights must be interpreted.
Thank you. Now moving on to next theme, which is Lex Sportiva versus national law. There is some conflict which exists, and there is some tension which exists between Lex Sportiva and national law. Lex Sportiva is really the law of sport developed by decisions of institutions such as CAS, and the basis for it is that how sports codes are to be interpreted, there has to be consistency about it. Now, coming to you, Kirtan, what are some of the challenges you see in enforcement of CAS decisions because of this issue? And if you have any views on the decision of Court of Justice in Royal Football Club Serang?
Thank you. I think there are two broad areas in which sport law typically comes into conflict with national or supranational legislation, and that's competition law and human rights. I won't go into human rights in much detail, but Caster Semanya's example is a good one. The general gender sexual disorder rules are a good one, which is, it's why must athletes be forced to inject themselves in order to compete in a certain category? And there's also the broader social question, why does world athletics get to decide what is woman enough? What level of testosterone is effectively woman enough? So there's that. But the other area where it quite often comes into conflict with sports law per se is the area of competition law. And more often than not, it involves ownership rights rather than pure sporting rights. The case that you mentioned, which was RFC Serang, which is a Belgian football club, was basically the club challenging third-party ownership restrictions and regulations which were brought into being by the FIFA Association. This was then, went through the entire appeals process. There was CAS, and then there was an appeal to the Swiss Federal Tribunal, which upheld these third-party rules. But a separate appeal was then launched before the Belgian courts, which are an EU court. The nub, or the outcome of that, is that CAS is subject to the jurisdiction of the Swiss courts. It goes up to an appeal to the Swiss tribunal. But under the Treaty for the European Union, European courts have the last right of review to decide matters in relation to matters of European law. There is an element of nuance around that decision. It's not all all matters of European law, but they found that there were certain aspects of arbitration in sports, like mandatory arbitration, which meant that it was all the more important for a European court to retain the final right of judicial review in respect of a decision. They also said that when the European Court is reviewing this arbitration decision, it's not going to be a de novo review. They are only going to look at the point of European law. But nevertheless, there is a niche area which has now come into conflict with CJEU jurisprudence because the Swiss courts are not European courts. The CAS has floated various options to get around this problem. They have suggested CAS with a Dublin seat because the courts of Dublin, Ireland would then become a European court in order to get around the problem effectively. So competition is one area where you frequently find that it comes into conflict with national law. Although I think the Serang decision is a very uniquely European problem, and even within the European system, as I said, if you read the decision, they've put in place lots of caveats there. So I don't think it's of necessarily wider panic or alarm, cause for wider panic or alarm. But in areas like human rights, you can see how several national legislations could come into conflict with sports. Lex sportiva, as you put it.
Nakul, coming to you. In your view, what should prevail when there is a conflict? And is there a way to balance the two?
So again, Manmeet, on this question, first, I must confess that I have absolutely no personal experience. Because I've never really had to deal with a real life case relating to an issue where the lex sportiva comes in conflict with a domestic legislation. But again, I'm going to take cue from what Mr. Salve said. You cannot let an athlete feel that they've been shortchanged. Now, two examples which I actually did look up, and I thought they actually made the point which I think is the relevant point to consider, is one, an example of a French FIFA player who challenged the restrictions that were there on his transfer. And the European Court of Justice took the view that, well, at the end of the day, you could not have provisions which would restrict your transfer because that was a basic violation of labor laws. Now, yes, it may beg the question that if you're earning £500,000 a week, or sometimes more than that, whether you ought to be governed by labor laws. But here's what it is. I mean, the athlete felt that there had to be greater freedom as to transfer, and the athlete got that, right? Another example that I did look up was in relation to a German speed skater who, in relation to a CAS ruling, said, I want a public hearing because I want my case to be heard publicly. And the German Constitutional Court said, yes, we uphold that right. Again, because I think the athlete was of the view that they shouldn't be shortchanged in a closed-door process. And when you have conflicts such as this, I certainly think that these laws which are there to protect the athlete, which may be slightly better when you're looking at, or I wouldn't say better, but laws which are, the law of the land, if it offers a better protection to an athlete, should certainly take precedence over what may otherwise be a contractual right that an athlete may have entered into without really realizing the implications of that right.
I think that's an interesting debate, whether you put the athletes' rights front and center, because without commercial interests at play, sports would not be and would not grow to the next level, particularly in a country like India. So I think that debate continues, that tension remains. Karan, from your
I must confess, and 20 years ago when I used to write a lot, I was actually writing for a golf magazine, and Tiger Woods has just come onto the scene, and I actually wrote an article on this. Is it Tiger Woods? Because has Tiger Woods made golf what it is, or has golf made Tiger Woods what it is? And I can tell you that article never got published.
Karan, from your perspective, when you're advising on sports investments or player contracts, how do you look at this issue, and how do you account for potential divergence?
I think typically with regards to player, coach and technical matters, we sort of rely on the arbitration because generally as sports franchises and team owners, we sign up to the regulations, the players do sign up to the regulations. So it's that competent authority that we trust in terms of resolving any such disputes. We had sort of one matter that sort of I dealt with where essentially there was something similar to what Nakul had pointed out with the Bosman case. Essentially, the player was out of contract. However, he was the previous club demanded a transfer fee from us or a release fee from the player, which, as per FIFA statute, is not valid. The previous club took the matter to court. We needed the player registered in time for that window because our season was impending. We took the matter to AIFF. Within 2 weeks, of course, they had a lot of tactics to delay this matter. AIFF transferred the registration, which was held by the previous club. And essentially, I guess they kind of came to their senses to realize that that's not the right way to go. So I think having that right adjudication with regards to sporting matters is key, and we trust the arbitration system. One interesting thing that I wanted to bring up with our sort of varied sports that we have, I think football has some really good regulations in terms of the internal mechanisms with the AIFF Player Status Committee. Then you have the FIFA DRC, and then finally CAS. It'll be very interesting, and it would be good to see that in other sports as well. Cricket being one, because now cricket, you have such a divergent, you have multiple leagues, multiple formats, players bouncing from one place to another. Whilst the ICC does have a dispute resolution committee, in our experience, that there's no one place that we can go to in case a player breaks a contract. So I think having some uniformity across it, basis best practice, would be really crucial.
Thanks, Karan. Ms. Gupte, my next question is for you. From a contractual perspective, which aspects of sports-related contracts do you see more disputes in, and how do you therefore mitigate them while contracting?
I see. I'm talking. Hello? Hello? Yeah. So for sports, since I'm speaking from a commercial lens, there is not much difference between the hotspots for the sports-related commercial dispute and other standard commercial disputes. But so the common ones are, I think the most prominent one is, of course, outstanding payments, because that is one of the major worries in any contract, because there are a lot of reasons for outstanding payments. Maybe there is a dispute over whether the rights have been delivered, whereas one party says the rights are delivered, the other says they haven't received what was committed. So sometimes it is just plain like companies, brands wanting to wriggle out of their payment obligation. So I think the most important concern, the most key concern is payment obligations. When you think about like from the sports, there's also termination also, sometimes termination provisions also give rise to conflicts. Because usually what we do is, especially with sponsorships and other partners, we do our best to tie them up, lock them up for the whatever the term they've submitted to in the contract. But in my experience, many times after the first year, they try to wriggle out, there's unauthorized exit, and then we have to fall back on how clear the termination clause is for them. So that is one hotspot I would see. From the commercial and business side, exclusivity is also one major area of concern, because you see, I'm again giving the example of sponsorships. Exclusivity for a sponsor is one of the key factors in associating with any sports property, because the basic intention of sponsorship is promotion. And no brand wants any competitor to be also associated with the property. So most of the major chunk, I would say, of the rights fee is quoted taking into consideration this exclusivity. And suppose tomorrow there's some ambush marketing which the sports property cannot control, or there is some ambiguity in the sort of exclusivity and product category that is committed to the sponsor, these things give rise to dispute. So this is one major hotspot, I would say, for sports-related this thing. Then, of course, infringement of IP, that also gives a lot of this, because everyone is using each other's marks. So like it has to be used in the right way, and also like there may be some breaches of warranties, that the marks are owned by a certain property, there may be claims on it. So this is also one of the major concerns. But I would say it is payment obligations that is the main critical. Yeah.
Thank you so much. I think we have some time left and we'll quickly touch upon cricket. Now, cricket is going to be part of LA Olympics 2028, and by virtue of that, it will have to submit to the jurisdiction of CAS. I think that gives rise to certain interesting implications, considering that cricket is one major sport which has so far been beyond the purview of CAS, and therefore there will be some fundamental changes. Karan, you briefly touched upon this. What are the practical implications of having cricket operate under different frameworks, and do you think a combined framework, a comprehensive framework, would give more confidence to teams like yourself and ease the free field for the players as well?
I think for any sport that's sort of part of the Olympics, CAS does get involved. We've had a few matters within cricket actually with some of the spot fixing scandal that happened that went to CAS, anti-doping regulations also that have gone to CAS. I think cricket is sort of at an inflection point, from a business perspective as well. I think there are so many leagues, competitions, franchises, formats as well now. I think conflicting windows also, where you have multiple sort of leagues happening at the same time. A lot of the players are retiring from international cricket and sort of taking up domestic cricket because the contracts are larger. We've had cases where players have sort of terminated their contracts unilaterally when, Ms. Gupte said, those provisions weren't there to sort of pursue other opportunities due to commercial reasons. So I think, again, leaning back on football, I think having sort of a unified structure where the ICC Dispute Resolution Committee could get involved at a second level, BCCI or the relevant sport bodies, internal governance and dispute resolution mechanism getting involved at a first level, then the ICC, and then of course CAS. I think that sort of has worked very well in football and would work very well with cricket. Sort of very unrelated to this though, I think the ICC would probably need to sort of maybe sort of have a leaner calendar, I would say, to avoid so many disputes, have particular windows like transfer windows where players can move between teams. It adds commercial value as well to have such a thing.
Thanks so much, Karan. While we are on the industry perspective, Ms. Gupte, do you find cricket's internal mechanisms, current internal mechanisms, adequate for giving commercial comfort, for structuring high-value deals? Clearly, those are happening. But would you prefer a different framework, or are you comfortable with what is there?
I think cricket today in India, at least, it has a very robust internal mechanism. But this mechanism is generally for internal governance. It's like an internal governance tool. So it's for matters such as integrity, player selection, ethics, conflict of interest. So they also have an ombudsman to, which is like a quasi-independent sort of a channel for grievance, specifically limited to conflict of interest issues. So it is a very robust mechanism. In fact, I was also part of one of the, some of the procedures of internal committees of BCCI in my IPL days, like early in 2007 and 8. So it is a very systematic and very professionally conducted committees and procedures. But these are, again, as I say, governance tools. So the commercial disputes still fall out of the ambit because Like even, for example, the franchisee agreements also submit themselves to external arbitration. So because commercial disputes ultimately need neutrality, they need enforceability, and like they need that expertise also to adjudicate on this, which internal committees I don't think are geared up for that.
Even player contracts have arbitration provisions. So
Yes,
yes,
I
there
mean, as a
is
first step, internal committees are around.
for the disciplinary pieces, I suppose.
Sorry?
For the disciplinary pieces, I suppose.
Yes, yes. From the disciplinary side, selections, anti-doping, ethics, integrity, all these governance, all these, even on-field, disciplinary actions and all these are submitted to the internal committees. And they work very well.
Sure. Thank you. Kirtan, so far we've spoken about how cricket can benefit from CAS. Do you think the reverse is also true? Can CAS benefit from cricket?
Thank you. I think, as we've said several times in the course of this panel, where the money is, disputes will follow. And I think more disputes will make for more jurisprudence, and that always helps, the development of lex sportiva. The one interesting, I mean, as an anecdote, the interesting trend, if you see disputes in the UK, so football is to England what cricket is to India. If you see sporting jurisprudence generally, every time there's been a flush of capital into football, there's been a spike of sporting disputes. The most recent flush of capital being money from Abu Dhabi, which has resulted in, the Man City Premier League dispute, which is sort of the called the sports dispute of the decade, or I think that's what it's called. So in terms of how cricket would benefit, CAS actually does publish its decisions. So perhaps published decisions will lead to greater consistency. And I think, as Karan mentioned, sunlight is the best disinfectant. Perhaps with greater scrutiny being placed and public scrutiny being placed on cricketing decisions, there will be benefit to the caste system. Benefit to the caste system and to cricket as well. The one interesting dynamic with cricket is, unlike in the past, where there wasn't as much digital observation of what the angle of swing of a ball is and DRS. A general feature of CAS arbitrations is that it tends to be very difficult to appeal on-field decisions. I think in the case of cricket, with the level of technological and digital accuracy that there is on field, that may make it all the more difficult to appeal on-field decisions for cricket.
Thank you. Nakul, my final couple of questions for you. First, do you see the high-value commercial disputes, which you said you've seen mostly in cricket, transiting to the other sports?
So high-value commercial disputes certainly are across the world, are in sports other than cricket. Because, I mean, I think that, in the world, football is big, golf is big, tennis is big. You go to Canada, ice hockey is big. You go to the US, basketball is big, right? So when you look at it from a worldwide perspective, sports disputes arise across different spheres. When you look at it from an Indian perspective, yes, it is cricket. Do I see that changing significantly in India? I don't think so, not in the near future.
All right. And finally, before we throw the floor open for Q&A, do you believe that we are headed into a future where the Indian bar will see more sports arbitration lawyers?
Is that a question again to me?
Yes.
Do I see an exponential growth? Again, I don't think so. I mean, we amended our Arbitration Act in 1996. It took 30 years to get an arbitration bar. And I can only tell you that a significant number of people in the arbitration bar still do more litigation than arbitration. So if you're looking at a subset of sports lawyers, I think that's going to take time.
Thank you. We'd be very happy to take any questions which any of you may have.
I am Suksham Chauhan. I'm from a London boutique firm. My question is with respect to sporting disputes in relation to sports people. And this is where the problem is in India. So you see a lot of disqualification does not you only arise at the national level, but also at the state level where athletes are disqualified on very random excuses or that your eyes are yellow and therefore you jaundice and you can't run. And the decision like these is what creates disputes. But as Nakul said, it would not come because you don't have time to challenge enough, because by the time you're going to challenge, your race is going to be over. So my question is, do you think sports arbitration, arbitration is too far, would sports disputes arise? And if at all, will there be a mechanism to decide these kinds of disputes which happen in district level, at state levels? So this is what I wanted to understand. Thank you.
So every sports federation, be it the district federation leading up to the national federation, is required to have a dispute resolution mechanism. Currently, these are mostly by way of internal committees, so the athlete does have a remedy. Now, the appeals in some of them, for some sporting federations, either the first appeal or the second appeal lies to CAS. In some of them, it lies to another internal body. So there is a mechanism. Now, on your point of whether that is very efficacious, perhaps not. And I think that's what needs to change. With arbitration, a completely external mechanism, there will be that kind of transparency, a confidential process still, but an external, neutral, transparent process which will ensure efficacious remedy.
I can add to that. I can just give you an example, of say tennis. India hosts some very small tennis tournaments. I know that, you go to the back of Beyond in Haryana and there'll be a $10,000 ITF tournament, but there'll always be a referee, and it's that referee who will then adjudicate a dispute if it arises in relation to a player, including in relation to a conflict that's arisen, disqualification, etc.
Typically in India, the model we follow is quite similar to the UK, where you have a district body, then you have the state body, then you have the national body, and that's how sort of the qualification towards you qualifying for the nationals, world champs, Olympics works. There are systems and processes in place, but yes, you're right, I don't think they're as robust. Case in point, Olympic qualifications. There's no calendar of events if you have to look at barring athletics, wrestling, no calendar of events, football, yes, great sport, boxing, no calendar of events. So just 6 months before the Olympics, the federation decides, oh, let's have qualifications now. So you may get another Vinesh Fogart case again, where essentially if you're going to drop down a weight or go up a weight category, you may just miss out by a few centimeters. So yes, I think the mechanisms are there, but I don't think they're that robust.
Anybody else?
Hi everyone, I'm Chitransh from Nishit Desai Associates. First of all, thanks to all the panelists for a wonderful session and a very informative one. My question is, recently the Online Gaming Act was passed in the Indian Parliament, and most of the discussions we saw here were about the in-person sports. But with the new regulations coming in to regularize esports, we might see an increase in the number of tournaments and the number of player pools from India and outside India participating in these Indian-hosted events, possibly. So what kind of disputes are you expecting in this field of esports? And is the Indian jurisprudence or the Indian legal or arbitral system ready for handling these kind of disputes?
I actually only have some facts and figures in relation to fantasy sport and esports based on the Deloitte Google survey which was done. And fantasy sport is supposed to grow in India to close to a $1.6 billion industry by 2030. And esport is supposed to grow to about a $200 million industry. So you're right. These are sports which are going to grow significantly. And again, there are certainly going to be lots of disputes that are going to arise. Can I predict what's going to arise? Well, the answer is no. At this stage, I don't think I can.
Nothing further from me. Anything else, or can we draw this to a close? Thank you so much for being a great audience. I know we had the post-lunch session. Thank you for hearing us out. Thank you so much. I'd like to thank all my panelists before I wind up for agreeing to be here at short notice. I know you all have very hectic schedules. Thank you so much.